Welcome to This Explainer. Today, we're dissecting a highly tense, completely viral courtroom confrontation to really understand the fine line between defending a client and, well, deceiving a judge. We're going to dive straight into the facts of a recent case, break down the legal arguments from both sides, and explore the foundational ethics that literally hold our entire justice system together. Okay, let's jump right in with this absolutely explosive, jaw-dropping accusation directed at Defense Attorney Edward Martell during a high-stakes felony hearing. Think about it. When a judge looks down from the bench and explicitly tells an attorney, "You lied to me," the entire atmosphere of that courtroom just shifts instantly. This wasn't just a minor disagreement over legal theory. This was a judge calling out what he saw as an intentional misrepresentation of the truth. So how on earth did we get here? Section 1. The recusal request, setting the courtroom stage. To really grasp what pushed the judge to make such a massive allegation, we have to look back at how this hearing kicked off on November 26, 2024. Attorney Martell was representing Darren Wilson, a defendant facing incredibly serious felony charges in Michigan's 14A District Court. We're talking kidnapping, armed robbery causing serious injury, first-degree home invasion, plus multiple weapons charges. The stakes could not have been higher. They were appearing for what's known as a preliminary examination. This isn't the actual trial. It's a crucial early step just to determine if the prosecution has enough probable cause to make those heavy charges stick. Right out of the gate, Attorney Martell made a super aggressive tactical move. He officially requested a recusal from Judge Cedric Simpson. Now, a recusal is basically a defense attorney looking at the judge and saying, "With all due respect, Your Honor, you're too conflicted to be fair in this case, so you need to step down." It's a really bold maneuver, and it's one you absolutely must back up with rock-solid facts. Martell's argument for this recusal basically rested on a few specific pillars. First, he argued the judge couldn't be a neutral magistrate because he had signed 2 search warrants for the case. Second, he claimed the judge had already handled a co-defendant's earlier examination. He anchored this whole legal argument on a 1974 precedent called People v. Burrell, insisting that the judge's prior involvement in finding probable cause for the search warrants legally disqualified him from deciding on probable cause for this preliminary exam. Section 2. Caught in a lie, the judge fact-checks the defense. Well, this specific argument completely baffled the judge. He didn't recognize the case details Martell was so confidently citing, which prompted a very tense recess to go review the facts. And upon a furious return to the bench, Judge Simpson immediately called out Martell's first major misrepresentation. He pointed out that he had absolutely nothing to do with the co-defendant's earlier hearing. The judge noted that the co-defendant in question, Christopher Harrison, had his preliminary exam handled by a completely different judge, Judge Barr. Simpson stated plainly that Martell's initial argument for recusal started with an absolute falsehood. But the deception went a lot deeper than that. Martell claimed the judge had actually heard witness testimony. He argued that because the judge had heard ex parte or one-sided witnesses to approve the search warrants, he was inherently biased. But in reality, as the judge fiercely clarified, he hadn't heard any live testimony at all. He had simply read a written document called an affidavit. In the legal world, looking at the 4 corners of a sworn written document to sign a search warrant is standard, everyday procedure. It is vastly different from taking live sworn testimony from actual witnesses. And this is where it gets wild. Martell intentionally cherry-picked the Burrell case. He tried to use the Burrell decision to suggest that any judge involved in a warrant is automatically tainted. But Judge Simpson literally read the actual text of Burrell aloud right there in court. And guess what? The 1974 ruling explicitly states that if an affidavit is just in written form and no witnesses are examined, there is absolutely zero prejudice to the accused in having that same judge preside later. Martell cited the rule, but completely and conveniently omitted the glaring exception that applied directly to his own case. Section 3. The prosecutor's rebuttal, setting the legal record straight. With Martell's maneuvering totally exposed and the judge visibly furious, the prosecutor, Ms. Hughes, stepped in, and she delivered a definitive knockout counter-argument that showed exactly what thorough legal preparation looks like. She systematically shut down the defense by citing 2 very specific cases, Cameron and Pitchford.
She pointed out that in the 2013 Cameron case, a judge who approved a search warrant went on to preside over an entire bench trial. Now, in a bench trial, the judge actually decides guilt or innocence, which is a way higher bar than a preliminary exam. In fact, an appeals court ruled that trying to recuse a judge just for signing a search warrant was a futile objection and a meritless argument. She clearly proved that a judge who signs a search warrant is absolutely 100% permitted to preside over subsequent hearings.
Section 4. The resolution. How the case actually ended. So, after all that intense back and forth, Judge Simpson refused to let the defense attorney just brush past the issue. He demanded a formal written motion, laying out a strict timeline right there. He gave the defense 2 weeks to put their claims on paper, after which the prosecutor would respond. But let's see how this all played out. Instead of actually filing the requested paperwork and, risking further sanctions from the judge for pushing a frivolous legal argument, the defense completely shifted gears. The defendant bypassed the argument entirely. On January 2nd, he pleaded no contest to 2 reduced charges: aggravated assault and attempted possession of a loaded firearm and a vehicle. By the end of January, he received a 365-day sentence, bringing a surprisingly swift end to a case that had derailed into such a dramatic procedural fight.
Section 5. The duty of candor, the core ethical lesson.
The true takeaway from this explainer isn't just about procedural timelines or the defendant's specific charges. It's really about the fundamental, non-negotiable ethics of the legal profession. This whole courtroom interaction is basically a masterclass in professional responsibility. Attorneys constantly operate in this immense, high-wire tension between fighting fiercely for their clients and upholding their ultimate responsibility to honesty. On one hand, you have zealous advocacy. A lawyer must do everything in their power to defend their client, to find loopholes, to challenge the prosecution, to demand a fair trial. But that duty is perfectly counterbalanced by the duty of candor. You're an officer of the court. Your arguments are supposed to help the judge determine the proper legal premises applicable to a case. And you just can't do that if you're actively distorting the facts or the law. And this whole situation brilliantly illustrates why rules like Michigan Rule 3.3 actually exist. This rule explicitly forbids an attorney from making false statements of fact or law to a tribunal, and it requires them to correct any false statements they previously made. While a lawyer certainly isn't required to argue against their own client, they cannot purposely mislead the judge by pretending a case means something it absolutely doesn't. Presenting a knowingly incomplete or distorted picture of the law isn't some clever legal strategy. It is a severe ethical breach that undermines the very integrity of the judicial process. So that leaves us with a pretty provocative question. How should the justice system balance a defendant's right to aggressive advocacy with the court's absolute need for truth? Was this just an attorney pushing the envelope a little too far for his client, or was it a dangerous crossing of ethical boundaries? Let us know what you think in the comments below. We're super eager to hear your take on this courtroom clash. Thank you so much for joining us for this explainer, and we will see you next time.